Well, I think it's important for victims to use their voice because there are untold thousands, actually, I think, within even this small area that need to hear that they're not alone, who need to hear that there are resources available and that healing is possible.
By using your voice, you can play an active part in a system that many people feel they have no control in.
It all starts with the victim bringing it to the attention of law enforcement, so it really does matter. As I tell people, regardless of what type of crime it is, that they have a lot of power so that they aren't victimized and they don't continue to be victimized.
Well, it's really important that a victim decide to be a part of the system. That's what, if the victim isn't a part of the system, it's just all about the defendant.
When the victim is involved in the process, it reminds all of us that we're affecting a person's life, and I think it makes us do a better job.
There are many ways for victims to be heard. Making a police report is one of them. Asking to meet with prosecutors and be actively involved in their case is another one.
If a victim can come in and talk to us at the charging stage before we make a decision, after the individual is arrested, we decide how we want to proceed with the case.
Going to court, even for pretrial hearings, if it's something the victim feels comfortable with. There's a tendency to forget about the victim in the criminal justice system, and the more the victim is involved, the less likely the system is to forget that victim.
It's important for the victim to testify because the jurors did not see the crime, they have no knowledge of it whatsoever. Therefore, if the victim doesn't testify, they don't know what happened.
Any way that we can get the word out that it happens, that the frequency of sexual assault and sexual abuse are tremendous, and that there are resources available to deal with it, and it can be dealt with, it can be healed from.
Filing a police report is an important step for victims of crime because it helps them to begin to use their voice in the system. Many people are unsure about whether or not they want to file a police report. Some may fear that what happened to them wasn't a crime. Others may have had an unfavorable experience with law enforcement in the past. Some may fear that their alleged offender will harm them or the people that are closest to them. But when you file a police report, it begins a paper trail.
It will make record that a crime occurred, and if the person offends again, it can be used to show a pattern or assist in future charges.
It's important to report right away, right when something has happened to a person. They need to report that information. Right away is when the information is going to be the most clear, where they unfortunately recall the events, what has happened, what the perpetrator looked like, if it's somebody they don't know, what they smelled like, what they heard, what was going on. They're going to recall those events, and that's going to help for any investigation.
When there's a report of a crime, any crime, and especially a crime of sexual assault, then it will trigger a law enforcement investigation, a police investigation. That allows us to start to not only hear from the victim, but oftentimes the victim has reported to other people as well, friends, family members, other people that can add credibility to what the crime was, and gives us a place that we can start our investigation and follow through for the courts.
More times than not, sometimes the victim will know the perpetrator. They will feel that the particular crime is just an isolated incident, that they're the only victim out there. Unfortunately, what we see, those of us who have been in law enforcement for a long time, is that these incidents aren't isolated, and that individual is not the only victim. And if it does go unreported, then the particular perpetrator feels that they can get away with it. They can do what they want. They don't have to follow the rules.
Very rarely do I talk to a victim after the process is over that is sorry that they participated in the process. It's not as bad or as scary as I think some TV shows and movies make it out to be. And I think that most victims feel empowered, and they feel that they did the right thing by reporting the crime and then cooperating during the process.
Also, it can be healing for some victims to file a police report. Even if it has been years since a crime happened, people still have the right to make an informational report at the police station. this can be an important part for healing for many survivors of crime.
The easiest way for a victim to get in contact with the prosecutor's office is to call and schedule an appointment. Many times the prosecutors are in court. If it's a question that the victim witness coordinator can answer, you can just give us a call.
Or they can contact a community advocate. The community advocate can work as a liaison between the prosecutor's office and the victim.
Sometimes people feel more comfortable having an advocate for them, and we are certainly willing to meet with victims alone, or if they want to bring an informal advocate like a family member or a friend, or if they want to have a formal advocate.
From the beginning to the end, if they're engaged in the process, if they have someone they can speak to, if it's not our office, they're not comfortable with it, that's not as important as that communication being provided to the prosecutor, provided to the folks who really are speaking for the victim in the legal process, and that is the prosecutor's office. There are a lot of opportunities for a victim to be a part of the criminal justice system. They aren't the focus, unfortunately, in the courtroom because it's between the state of Washington and a particular defendant, and oftentimes the defendant has all the rights in the courtroom, but a victim has very, very important rights all through the process.
They have a number of rights to be heard during the investigation, and they have a right to be consulted during any plea agreement negotiations, and they have an absolute right to be heard at sentencing of the person who assaulted them or molested them.
One of the things that we try to train our police officers is when we're dealing with victims of crime is to be compassionate, first of all, and understand where the mindset is of the victim, because people react differently when they've been victimized by crime. A lot of times there's a lot of emotions involved, there's guilt involved sometimes, there's people blaming themselves for situations that they shouldn't be blaming themselves for. And so we try to work through all those emotions.
Everyone has rights, and we need to be able to speak up and be able to state what happened to them, and nobody has the right to take advantage of another person or to harm them or hurt them.
A victim's opinion can affect the charging decision. The prosecutor is the one that actually makes the charging decision, but in reviewing it before the prosecutor does make the charging decision, they would like to get the input of the victim.
In situations where an offender may have the option of receiving treatment instead of jail time or along with jail time, prosecutors are often interested in what outcome the victim would like the case to have.
What do you want to happen with the case? That's the sort of questions that our office and our attorneys try to ask the victims up front. It isn't always followed. I mean, that's one of the things that's difficult for a victim to understand, because we do have sometimes the bigger picture. In other words, we see the potential harm to others, not just the particular effects to a victim.
Having the best witness, having direct information, making sure that as they provide information that they don't leave anything out as well. And so we want to make the best case that goes off to our prosecutor's office so that when they file charges, that we're going to be able to hold the offender accountable.
I think the victim's opinion can affect charging decisions. It certainly is not going to determine a charging decision. So the charging decision has to be based on the facts of the case. Sometimes the victim can give us more information, and sometimes that more information can give us a different reason to may allow us to file a more serious charge, for example.
In the state of Washington, it is the prosecutor's decision to make what charges, what are appropriate, but it's also the victim's right to have input at that decision-making process point, so that they can at least let the prosecutor know where they stand on that particular case.
And then once again, I think talking to the victim during that phase, it's a reminder, no matter how good and sensitive, compassionate a prosecutor is, we always are going to do a better job when we remember we're dealing with an actual person as opposed to a file. It's important for a victim to testify in a trial, and it's because often we can't get a conviction without the victim's testimony. There are serious limitations of prosecutors' ability to present a case. We have to have direct testimony. So we can't have a police officer come in and testify as to what a victim told them in the police report. We have to have that victim testify themselves.
If we don't have a victim there in the courtroom not available to testify to present their evidence to the judge or the jury, we really don't have a case.
The jurors did not see the crime, they have no knowledge of it whatsoever. Therefore, if the victim doesn't testify, they don't know what happened.
Gives them a sense to hear from their perspective what they thought, how the events occurred. It's really important because if you don't have the victim's statement, or if they're not testifying, then you may only hear the other side. You may only hear the perpetrator's side, which may not be as accurate information.
It is also important for the judges and the juries to see a victim testify because it lets them know that the case was important enough for them that they are willing to experience something that's not enjoyable in order to see justice served.
And the process of the testifying is a very structured program. Rules of evidence apply. Victims don't really get to say what they want to say to a judge or a jury. Oftentimes they can't even talk about things that happened in the past between them and the suspect if things happened in the past. So it's a very difficult, a very sometimes intimidating process to stand in front of strangers and tell you what happened to you and how you were victimized. But we can't proceed without it. It's critical.
The pre-sentence investigation, you'll also hear it called a PSI, is done by the Department of Corrections, and it's important that the victim information get put in there because the judge uses that. It's a very detailed report, and without the victim's input, the judge does not know that, how it has affected the victim.
Because they give sentencing recommendations to the court, it is important for them to know how a victim feels about a case and what they would like to see happen in it.
The pre-sentence is very, very important because it's a written document that goes with this individual defendant all the way to prison and all the way out when he gets released from prison sometime in the future. So they know the true facts.
And it's important, even if the victim is planning on speaking at sentencing or filling out a formal victim impact statement, it's important for them to cooperate with the Department of Corrections PSI because a lot of times the judge follows that recommendation, and sometimes the recommendation writer will have his or her opinion affected by talking to the victim, and sometimes the judge really reads that PSI. He may read the PSI first and kind of form an initial opinion about the case before he goes into court for sentencing that day.
I've seen cases where a pre-sentence investigation, they weren't able to contact the victim. They really don't know what really happened. I mean, what's in the information that's charged against the defendant, what's in the affidavit of probable cause, are very small snippets of what really happened in any particular crime. The true story is really contained in a pre-sentence investigation and also the victim impact statement. So those are important to go all the way through the system with a particular defendant.
A victim impact statement is a statement that is either directed at the court or a pre-sentence investigation committee. It is the opportunity for a victim to have a voice in the system. It lets people know how being victimized has impacted their lives.
A victim reading their statement during sentencing can be impactful because it gives emotion to the statement. If it's just written on a piece of paper and handed to the judge still doesn't have that feeling of what it's done to a person's life.
Oftentimes, especially when it goes to juries and even a judge making a tough decision, a lot of times it's hard for people that have never been in those shoes to be able to understand what is going through somebody's mind. And I think that it really is an opportunity for a judge or a jury to hear firsthand how that particular crime has impacted that victim.
The victim impact statement, I think, really can remind the judge as to what really happened. And so the focus isn't just always on the offender, and that's something that troubles them in the criminal justice system. There tend to be so much focus on the rights of the criminal defendant and the rights of the offender at sentencing that sometimes the victim can be forgotten. If the victim has a victim impact statement, it's a reminder for everyone, especially the judge, that this was a horrible crime and that it impacted the victim and impacted the victim this way, and that's why the offender should either be held accountable or be treated, or a combination of both.
There are no rules of evidence that limit what the victim can say. There are no rules. The lawyers don't get to cross-examine the victim. There's nothing. It's simply the victim being able to convey how this particular crime affected them and what they think they would may be appropriate for the particular defendant that's being sentenced before the court. One of the best ways to do that is for a victim to speak from the heart. I have had victims come in and ask what they should write, or ask me to write the victim impact statement for them, and I tell them that I can't tell how you feel. I can't tell you how this case affects you. You have to put that in words, either on a piece of paper and have someone else read it, or have it read yourself to the judge.
Your Honor, there's so much I want to say to you. I just don't know how to put it into ladylike words. When I tell jokes, they are not as funny like they used to be. Not usually want to go out and play anymore. When I play games, I feel that I cannot play like I used to. Is always upset, angry, and frustrated because they think they should have done something to stop him from hurting me.
Nobody should have the power to take advantage of another person, whether it be an adult or a child. It's really important that their voice be heard and that they can tell how the crime impacted them. They're the main link. They can stop the abuse. It's really important for them to speak up.
The primary thing again is for creating awareness, and why it's important is that I don't think I've ever talked to a single survivor who didn't think that they were alone, that they didn't think that there was nobody else out there that knew what it was like.
When somebody shares their story, it's very healing for them, but it's also can be healing for other people, and knowing that you're possibly helping somebody else break the silence or help them through the healing process can be really empowering and increase self-esteem and self-worth for the person sharing. Just knowing that they're helping other people, I think, can be very therapeutic.
Well, I think there's a lot of things that victims can do to use their voice to be heard, and it's everything from at a community level of being involved and being there to help other people that have gone through similar types of situations.
Being public about it and helping to make people aware, even on an individual level, impacts, because again, the isolation that sexual assault and sexual abuse have just carry with them gets broken when somebody else says, yeah, that happened to me and I've made it through. Then people start to think, maybe me too.
I like to call it survivor's pride, because it's almost a sense of accomplishment that they've been at this point and now they're here, and through this traumatic event there's been growth and resource development and assets and strengths that they never knew existed, and there's almost a sense of accomplishment there, that I have these skills now I didn't know I had before, and I am a survivor and I made it through this horrible experience, and assisting other people, and you can make it too. I think that can be so empowering for people.
But also, there's often time that victims can come forward. A lot of laws are changed as a result of victims coming forward and helping other victims.
Legislative efforts are another really great way for a victim to utilize their voice in assisting in changing laws around victims' rights.
Speaking with their legislators about concerns or changes you believe need to happen to protect community members and try to prevent future victimizations like the one they experienced from happening to others. People can also testify at the legislature on issues. Testifying always makes words on paper come to life.
The legislature has a tremendous impact on what we do in the courtroom every day, every week, both in resources and in the laws that we deal with. The Victims' Rights statute was as a result of victims standing up and say, we have a right to be heard in the courtroom. We have a right to have someone present with us when we're having these defense interviews. So it isn't just the judges and the judicial system that's making the rules. It is the legislature. And victims have a strong impact. The legislators listen to victims. They listen to their stories. They're empathetic to the victims. They really want to help the victims through the process. So they can have a voice, not only in the courtroom, especially at the sentencing, but also at the the state legislature.
So with that said, I think there are many benefits to a survivor using their voice. I think it can be very empowering and freeing for somebody to say, this is this horrible experience. I'm now on my 2 feet again, and I made it through. Although the pain's always going to be there, however, I can move forward, and it's going to be manageable, and it will lessen each day. And to get that message across to other people, I think also can be really helpful to them, because they realize that they're helping other people either break the silence or help them through their own pain.
1976, Fresno County, California. Chief Probation Officer James Rowland created the first victim impact statement to provide the judiciary with an objective inventory of victim injuries prior to sentencing. In 1981, the Washington State Legislature passed the Victims' Bill of Rights, giving victims for the first time statutory rights, including the right to give a victim impact statement to the court. RCW 7.69.030. To submit a victim impact statement or report to the court with the assistance of the prosecuting attorney if requested, which shall be included in all pre-sentence reports and permanently included in the files and records accompanying the offender committed to the custody of a state agency or institution. With respect to victims and survivors of victims, to present a statement personally or by representation at the sentencing hearing for felony convictions. In 1990, Washington citizens adopted an amendment to our state constitution, Article 1, Section 35, which provides victims and survivors a right to make a statement at sentencing and at any hearing where the defendant's release is considered. Washington State Constitution, Article 1, Declaration of Rights, Section 35, Victims of Crimes Rights. Effective law enforcement depends on cooperation from victims of crime. To ensure victims a meaningful role in the criminal justice system and to accord them due dignity and respect, victims of crime are hereby granted the following basic and fundamental rights. Upon notifying the prosecuting attorney, a victim of a crime charged as a felony shall have the right to be informed of and subject to the discretion of the individual presiding over the trial or court proceedings, attend trial and all other court proceedings the defendant has a right to attend, and to make a statement at sentencing and at any proceeding where the defendant's release is considered, subject to the same rules of procedure which govern the defendant's right. In the event the victim is deceased, incompetent, a minor, or otherwise unavailable, the prosecuting attorney may identify a representative to appear to exercise the victim's right. This provision shall not constitute a basis in error in favor of a defendant in a criminal proceeding, nor a basis for providing a victim or the victim's representative with court-appointed counsel.